court, then you get to county court. When you go from JP court to county court, it's a new trial. When you go from county court to the next appellate court, you don't get a new trial unless they order one. You just get an appellate review at that stage. So that's the difference. All right. Anything further, Mr. Boy, or do you rest?
Plaintiff rests, Your Honor.
All right, Mr. Way, it's now your opportunity to call any witnesses or offer any documents into evidence, and you may call your first witness at this time.
Yeah, my first witness, I would like to call Jennifer Alvarado.
All right, Ms. Alvarado, if you would get closer to that microphone, please, and raise your right hand, I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name for the record, please.
Jennifer Alvarado.
All right, Mr. Way, you may ask your first question. Go ahead.
The first question I have to ask is, why would you tell me your name was Amanda Cantu? They've been having me under the impression.
Mr. Way, just question, answer. Question, answer. When it's your turn to testify, you can tell me more. But right now, just question and answer.
I apologize.
No worries. Go ahead, Ms. Alvarado.
Your Honor, I'm going to object based on relevance.
It might or might not be relevant given Ms. Cantu's statement that she hand-delivered something to him. So it might be relevant. It might not be relevant. I can't tell yet. I will overrule the objection. You may answer the question if you can.
I have never stated my name as Amanda Cantu.
Next question.
No witness.
That's not a question. You have to ask her a question.
No. I was saying that was it for the witnesses.
You said no witness. Oh, you mean you passed the witness? Okay. I don't think he has any other questions for Ms. Alvarado. Ms. DuBois, do you?
No.
I just got to speak, apparently.
Okay. All right. Thank you, ma'am. You may step down and you all may mute your microphone. Okay. Mr. Way, you may call your next witness.
Okay. That's it for the witnesses. I apologize.
So you don't have any other witnesses that you want to call? Did you want to offer testimony yourself?
Absolutely.
Okay.
Absolutely.
Well, if you'll turn your video camera back on. There you go.
Sorry. I didn't know it was off.
That's all right. It just went off for just a second there.
Okay.
If you'll raise your right hand, I'll swear you in.
All right.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. State
your name for the record, please.
My name is Alan Way, representing myself pro se in this case.
And your last name is spelled W-E-A-H, correct?
Yes, ma'am.
All right, very good. Now, Mr. Way, let me just point out a couple things just as we get started. Because you're representing yourself and you're acting as your own lawyer, it would be a little silly for you to ask yourself a question and then answer it. That really wouldn't make any sense. So because of that, you'll be allowed to testify in what we call the narrative form, meaning you don't have to ask yourself a question and then answer it. You just get to give me the information. Okay. However, couple things to keep in mind. One, if Ms. DuBois raises an objection, you'll know that because she's going to say objection, right? Or if I interrupt you, I need you to stop your testimony until I can deal with whatever reason I might have interrupted you or whatever reason Ms. DuBois wants to raise her objection. So at that point, I need you to stop your testimony till we can deal with those interruptions, and then you can be allowed to proceed. Does that make sense?
Absolutely.
All right, couple other things to remember. One is you tend to talk pretty fast, and in order to be respectful to our court reporter who's trying to take down a clear record, I'd ask you to slow down a little bit so that she can get everything you're saying onto our record. Okay?
Gotcha.
Last thing is I need you to stay focused only on the issues that are before the court and not on things that I don't have jurisdiction to deal with or can't handle. So right now it's kind of simple what we're doing, but I want you to be able to tell me your story because I know you have a story to tell and I want to hear it, but I want you to do it. I want you to do it slowly enough that we can hear it. And don't forget to let me deal with these objections. The final thing I want to point out is that we've been going a while, and given the pace of everybody's speech pattern, I'm going to have to give Ms. Duet a break here shortly. So probably in about 15 minutes or so, if she can hang on that long. looks like she can. All right, good. She's telling me she can go another 15 minutes. I'm going to break at about 9:15-ish, and then we'll take about a 10-minute break, and then we'll come back and finish up whatever we haven't finished by then. But I've got to give her a rest at some point since we've been at it for over an hour. Okay. All right. Mr. Way, you may proceed now with your direct examination.
Yeah.
And then following that, Mr. Boyd will have an opportunity to ask you some questions on cross-examination. But for now, we'll start with your direct examination, and you may proceed.
Yeah, I wanted to start with when I moved in. The first thing that happened was I moved in and signed the lease and everything like that. I checked out building 4. Long story short, they ended up moving me to building 6. It's on the clubhouse camera. When I met Amanda, she gave me her card with her name on it, and it said Amanda Cantu. That's documented. I've asked for subpoenas. I've asked for 4 subpoenas in order to get the information in this case, because that's actually relevant now. Because Amanda Cantu said she delivered a notice to vacate, and she hand delivered it to me, which technically was Jennifer Alvarado. If that makes any sense. Okay, so
I understand what you're saying. Keep going.
Yeah. So basically, they evicted me. I had moved into the apartment, I think August 21st. September shows up, UDR, like some sort of billion-dollar corporation, comes in and buys out this place. They upgrade the locks, do a bunch of smart locks. Long story short, I'm on camera right now. Every aspect of my life is on camera. Irrespective of that, you could just look at the original petition. The original petition itself does not give any merit to even have the trial. Because 1, they had all the money at that point in time, signed and date stamped, and then they weren't suing for anything. I hadn't violated the lease or I hadn't done anything. There was 0 cause to even evict me. The only outlet that I would have is to appeal the eviction. To make any sense, if I wanted to stay there, I would have to appeal the eviction. So as of November 1st.
But may I just ask a clarifying question?
Mm-hmm.
The testimony in the record so far from the plaintiff is that you were to pay $1,356 per month.
Mm-hmm.
And that to date, you've only paid $720. So when you say you didn't owe any money, I'm confused by that. Could you explain to me the dollar amounts? And if you could, we're going to take a break here in a minute. If you don't mind waiting to enjoy your breakfast or snack or whatever you're eating, if you could wait and do that until we take our break, that would be really, really helpful to me. So I need you to clarify. You're saying you didn't owe them any money. They're saying you never paid even a full month's rent. Could you just help me understand that?
So what's the amount? 1,300 and what? 56?
I believe the testimony in the record is $1,356 per month.
So that's September, October, November, right? Okay, so that 1,356 multiplied by September, October, November equates to $4,068. If you go back to the original petition, this is what I'm trying to argue here. They literally have the document signed by an authorized representative stating the amount of rent claimed as of this date of filing is $4,068.00. My thing that I'm saying is essentially there was no cause, there was no merit to evict me because they had rent. They said they claimed it on my behalf. They're not suing for anything. I haven't broken any violations or any lease. There is literally the reason why we're here right now. There's no other option for me if I wanted to keep my location other than to appeal.
Here's what I'm asking though, Mr. Wayne, for clarification. They're telling me that you owe $1,356 a month.
Yes.
And that you have only paid $720.
No, incorrect.
Okay, that's what I'm asking you to tell me. So they're saying they're saying you owe $1,356 every month. You owed it in September. You owed it in October. You owed it in November. And they're telling me in all that, they're telling me in all that time, you've only paid $720. So I need you to help me understand the payments that you've made. Can you talk to me about that?
Okay, so on November 1st, at 5:25 p.m., there was $4,068 paid on my behalf to Estancia Villas, period. In addition to that, that's not even accurate because My deposit in conjunction with the August month adds an additional $720. So in reality, it's actually.
So, hold on. When you say that a sum of $4,068 was paid on your behalf, can you tell me
Yes.
more about that? Who paid it? Where's the check? Tell me more about the payment and so forth.
The managers paid it for me because they've been monitoring me. They've been putting me on camera. They've been putting me on camera and circulating my information. There's a bunch of nonsense going on here. And that's
So
what the payment was for.
So hang on a second. When you say that the managers paid it for you, tell me more
Yes.
about that. Who
Yes.
paid it? How did they pay it?
Jennifer Alvarado. It doesn't matter. It was electronically paid for me. It was taken care of on my behalf for me. They have it documented here, time and date stamp.
Why would the managers pay
Thank
your
you.
rent for you?
Thank you. Because they have some organization going on here where they're trying to demasculize men. And as soon as I stepped foot in here, ever since then, it's been a whole campaign to separate my genitals from me. It sounds ludicrous, but there's there's visual communications, there's emotion of continuance. You guys are treating this trial like it's just some sort of eviction, copy, paste, cut, paste, and that's it. There's so much information in here.
Okay, hang on.
That's why it was paid. That's why it was paid for me.
Okay, so hold on. So let me just back up because I want to do this in sort of pieces that I can understand and we get a clear record.
For sure.
If I understand what you're telling me that on November 1 at 5:25 in the afternoon on that day, Ms. Alvarado, on behalf of Estancia or on behalf of herself?
Nope, I'm saying prior to that date, right? It doesn't matter if she says she's going to pay it for me, it doesn't matter. Prior to that date, it was paid. It was paid on my behalf for that reason exclusively. Me being on camera inside my location.
Okay, so let me just be clear.
Privacy.
Do you know in what way money changed hands from Ms. Alvarado or anybody else on your behalf to pay your rent? Can you tell me more about how that payment was made? Tell me what you know about that other than what somebody may have told you. I don't want you to tell me what they told you so much as I want you to tell me what you know happened, if you do.
Management paid my rent prior to that date. It's on it's a legal document right here.
How do you know they paid your rent?
Because they told me that they would. I've been on camera. Okay. They've been circulating my information on social media, laughing at me, putting me.
Who told you that they paid it? Who told you that?
The manager, Jennifer Alvarado told me that she paid it. The manager.
Okay. So let me just be clear.
Prior to that date right there. It was paid on my behalf.
Okay, let me be clear. Let me be clear. Your testimony today is that on or before November 1st, $4,068, the $4,068 that you owed in rent to that date was paid on your behalf by the manager of Estancia Villas, Ms. Alvarado.
UDR essentially, but through her as an authorized agent. UDR essentially, but through her as an authorized agent.
All right. So they paid your testimony is that Ms. Alvarado on behalf of her employer paid your rent for you.
They wanted me to leave is why they put that number down there. So they paid the rent to have me leave. That's what that was about.
Okay. All right.
And the reason why, and I'm still in the testimony if I'm okay to continue.
Yes, you may continue.
Okay. The reason why that number is down there is because I've been monitored. They've installed smart locks out here and they have access to my codes. On the inside of this door, I have have the ability to lock the door and prevent anybody from coming inside here. When I exit and I go to the outside of the door, it's an electronic code. When I leave, these guys have me on GPS. I come back inside, my stuff's all over the place. They're setting up spy cameras and all kinds of nonsense and circulating my information. Estancia Villas in general. And when I mentioned that thing about them trying to separate my genitals from me, not physically, but they've been doing all kinds of psychological tactics to do so, like messing around. And I have the visual communications. First and foremost, let me go ahead and reiterate that this was supposed to be a jury trial. The fact that you guys are trying to consolidate the trial, they've been doing so many things to just shut me up, put me in jail. I literally started submitting exhibits to the case. As soon as I submitted an exhibit to the case, here comes an interception from Travis County Sheriff's Office and Travis County Civil Division as if I did anything wrong. We're literally in an ongoing dispute and these guys come in and intercept. This is a massive case I was trying to exhibit here. The first thing I got to say is, just on the merits of the original petition, like they do not have cause to evict me. Like I said, it was paid on my behalf That's how much they collected. It was the exact amount. And now look, they don't even have a lease violation. They don't have a holdover. They don't have anything for applicable attorney fees. And it's because I know what I know. The reason for the countersuit was because I wanted to relay what I know. You guys were trying to separate it and do all kinds of stuff. The way that they moved about this was absolutely, they shouldn't even process this case. The first thing they should have said was, hey, this dude didn't even do it. What are you trying to evict this dude for? And if I would have co-signed it, then they would have permission, but I didn't. So here
Let
we
me
are.
stop you there. Let me stop you there to ask another clarifying question. Since you take the position that your rent has been paid through November, right? All right. So can you tell me what amount of sums have been paid by you for the months December 2023, January 2024, and February 2024? Have you made any rent payments as required under the lease agreement for the months of December 2023, January 2024, or February 2024?
No. And the reason why, if I'm still inside my testimony, is because with them only suing for the right of possession, and this was told to me by the JP courts, I have documentation of my statement of inability to pay. It literally says, so I've been able to not pay rent. They didn't sue me for anything. That literally prompted me not, they just took my statement of inability to pay. So essentially, I don't owe anything to the JP court, and I don't owe anything going forward until we come to trial.
Let me stop you there.
And let me find the document. I'm sorry.
My question was simply whether or not you paid rent. Your position is that your rent was paid through November, that someone paid it on your behalf. That's what you told me. And if that's true, then the question is, on December 1, did you pay rent? Did you pay rent to them?
Okay. Well, on December 1, I did not give any money to JP Court.
Okay, hold on. Mr. Way, stop. I'm still trying to get to the sort of clarifying question I'm trying to ask. So if I understand correctly, you think your rent was paid through November. And so I understand that. If that's true, then the next point in time in which you would have owed rent would have been December of 2023. And if I understand your testimony, you did not make a payment of rent in December of 2023. Is that right?
No, I did not. Can I continue with the testimony?
Well, hang on. I'm trying to clarify what you said about the payments.
Yes, ma'am.
Okay. So you didn't pay in December, you didn't pay in January, you didn't pay in February, correct?
It was paid.
Right?
I had a zero balance in in December, January, February, and anything beyond that, I have a zero balance. So technically,
okay, wait,
I
stop,
did pay.
Stop. I'm asking about things you actually did, not your legal theories. That's why I'm trying to back up and clarify. You're giving me your sort of legal theory about why you owed or didn't owe something. That's not my question.
I got you.
I'm asking a very simple, factual question. Did you make a payment of $1,356 to Estancia Villas in December 2023? Yes or no?
I paid $0 to Estancia Villas in December 2023.
Okay.
As far as December?
No. Just getting some facts here. In January 2024, did you make a payment to Estancia Villas in the amount of $1,356? Yes or no?
No.
Okay. And in February 2024, did you make a payment of $1,356 to Estancia Villas? Yes or no?
No.
Okay. Now, next question. The affidavit of inability to pay. That is a document that you filed in the court file, correct?
Yes.
Okay. I just wanted to make sure factually I understood what you were saying. Now you can continue with your testimony.
Sorry. Yes. So basically with that statement of inability to pay, they had a cash surety balance of like $277. And this is why I'm actually suing JP3 too, because they had a cash surety of $2,700, which basically I substituted with that statement of inability to pay. And it is co-opt with the fact that they only sued for right of possession prompted me to only owe $0.00 going forward, confirmed by JP Court. And I have the documents to prove it. So technically, the original petition, I didn't owe any money. And then Estancia Villa accepted it. They co-signed it. They had the opportunity to say no. They accepted it. They signed off on it. I have that too. Now going forward into the new trial here, my stuff was accepted as far as me not being able to pay. So we have the initial petition, irrelevant. Moving forward to the new trial, I'm not paying for December, January, February, or anything beyond because they only sued for right of possession. Here we are in court to argue about the merits of the case. Fuck with me. Claimed it
Your
was
Honor,
inaccurate.
I'm gonna object. I'm gonna object again based on relevance.
stop,
to the de novo trial.
Stop.
I'm just trying to summarize.
No, yeah, so I'm gonna overrule Ms. Du Bois' objection, but I'm gonna ask you not to reiterate because that's really just repetitious.
Okay.
Everybody's been listening all morning, certainly me.
Perfect.
We have a record.
Just
I don't
as long
need
as
you
I'm
to
clear to you guys.
summarize. I don't need you to summarize or reiterate. I need you to tell me something you've not already told me.
Okay, so you've already gotten the portion of me not owing rent because of the
You don't
basically
need to
told by the tenant.
summarize. You don't need to summarize.
Okay.
Keep going. If there's anything else, keep going.
I'm just thinking.
No, take your time. I'll tell you what, let's take
Yeah.
our break round. That way you can give time, you have some
Yes,
time.
the juice is flowing, right?
Yeah, well, organize your thoughts, I was thinking.
Yes, ma'am.
All right, let's give our court reporter and everybody else a comfort break. It's 9:25 by my watch. Let's take 10 minutes and we'll resume at 9:35.
Judge,
Perfect.
it's 11:25, Judge. Not.
Sorry. 11:25, we'll resume at 11:30. I'm looking.
What the heck? That was so interesting. That bitch lying and I move and I fucking move. Bitch, you got cancer. Die. Stupid ass. You sitting there lying, you know, bitch, you told me your name was Amanda. Tell me how much of a fucking lie that is. You're on the fucking original petition, you're lying. All kinds of shit. The statement of inability to pay, you changed this shit. Stupid. Let me go. I think it's events prior. Exhibits, events prior. There we go. What a fucking idiot. You can tell by her body language too. Her body language, she's just looking all over the place and I can't believe I gotta say this and I'm such a liar. Like, what the fuck? And I'm gonna appeal that shit. Fuck with me. Stupid ass. That shit's annoying because I can't. That shit's really annoying. And I move, and you're trying to make me look like a bad person, but I'm like, what the fuck? Yeah, and I'm getting back to my trial, bro. And I fucking got a job and got arrested. That's what the next part you need to talk about. Yes, that's the next thing you need to talk about. He said, yeah, so I basically got arrested and they followed suit and decided to do all this nonsense, bro. All my shit's on file. You can't reset the trial, bitch. Fucking process faster. I guess that lady does have to jot down everything I'm saying. But I keep getting interrupted. Your demand, bro. Your demand for a jury, take notes. Appeal for rent payment. Notice for rent. For your demand. Your jury trial for demand. Yeah. Yeah. I countersheet them and I put a fucking demand on there. And then don't let that slide, bro. Don't let that shit slide. Don't let the demand slide. You know what I'm saying? and don't let the fucking, well, I'm not paying rent. Like, I didn't pay rent because we had everything. You know what I'm saying? And then after I didn't pay rent, it's because I didn't owe anything. You know what I'm saying? So then here we are for trial. I asked for a jury trial. Why the fuck are we here? I've been asked for it, man, for a jury trial. I'm not playing no games. I'm gonna show them too. And then don't forget to tell my Aaron is lying and doing a bunch of stuff that's literally against stuff like that. Yeah, I'm gonna tell them too the date. The date. Yes, thank you. Date of.
I hope you don't take this the wrong way, but can I just say, kind of look like an asshole.
Yeah, I know my brother judge is actually impartial.
This court is back in session.
Oh shit. Oh. There's no way.
All right, thank you for that. I know the court reporter appreciates the break, and everybody else could have time to get comfortable. So good. Mr. Wade, let's continue then with your testimony so that you have time to wrap up with all of your.
Start broadcast. Okay.
If you just hit that, yeah, there you go.
If I say stop share, will that stop everything?
It will stop your share. They won't take
Okay.
you out of the Zoom room. It just stop your share.
Yes, ma'am. So I just want to point out that during this whole thing with the appeal after the decision from the judge, I had 5 days to appeal, and I basically submitted my statement of inability to pay. But last minute, they tried to change it. If I zoom in over here, they asked for 1,356, and I basically clarified. I had to call. I literally left work. I was about to go pay this money and everything like that, and I had to call to verify because they told me initially since they sued for right of possession only, I wouldn't have to pay anything. All clarified. Got
Your
that.
Honor, I'm gonna object based on hearsay.
Well, I'm about to show you. You should have waited. You should have waited 30 seconds.
No, Mr. Way, she has a right to object when she wants to object, as do you. It's okay. She doesn't have to wait. She can object. I'm going to sustain her objection because whoever told you is a hearsay statement. So that's a legitimate objection. I will sustain it. Please don't tell me what anybody else said. The exception, though, one of them to that rule is you can tell me what the representatives from Estancia may have told you, but not some other person you've not identified. It was sustained for that reason. Let's move on and just give me the facts. I'm right.
Yeah.
Right. This part of the process, the evidence phase, is where I get the facts, and then in closing argument, you all can argue the law to me, and then I'll make a decision.
Okay.
But right now,
Sure.
I just need the facts. What happened? What'd you do?
Well, it's a fact that after I corrected them, they went ahead and changed it back, and I didn't owe anything. And then after that point, they actually signed off on that's Estancia Villas right there. After they corrected it for not the 1,300.
Well, hang on. If you'll go to that. I see that document, but you scrolled pretty fast. I couldn't read the other two. So I see this one. And just for the record, stop. Hold on. Go back down a little bit. Just for the record, the document that Mr. Way is showing us on the screen right now. Can you scroll down just a little bit so I can better?
Ma'am.
That's good. He's showing us on his share screen, tenant's notice to appeal for non-payment of rent. Dated, it has a date of November 21, 2023, and then signed by Mr. Way. Scroll down and let me just note the next one. The next document that he's showing on his screen is entitled Notice of Appeal with Statement of Inability to Afford Appeal Bond / Surety Bond, signed by Mr. Way, also, or has his, what appears to be his signature, and dated also on, looks like November. I can't tell if that's the 27th of November. Is that what it says?
Yeah, let me clarify for you. So on the 16th,
that's better. Hold on. Just let me note what they are.
Yep.
November 27, 2023. Thank you for blowing that up. Scroll down. I'm going to tell her, note the third one. The third document is entitled, it at the top says confidential is kind of the title of the document, if you will. Dated November 21, 2023. It is on letterhead of Judge Sylvia Holmes, Justice of the Peace, Precinct 3, Travis County, in this cause number. And it is a document also signed apparently by Mr. Way with the date of November 27, 2023, which further says request to appeal by. The issue of whether or not you are entitled to a jury has already been decided by a judge. I do not work I'm not an appellate court judge. I'm a trial court judge. And so my decision gets appealed to the Court of Appeals. Judge Wong's decision gets appealed to the Court of Appeals. We're not the boss of each other, so to speak, right? He makes his rulings, and if you don't like his ruling, you got to go to the Court of Appeals. I'll make a ruling. If you don't like my ruling, you can go to the Court of Appeals, but he can't overrule me and I can't overrule him for things that have already been decided. Does that make sense? That doesn't mean that people can't ask they be reconsidered, or that certainly is something that could happen.
I hear
But
you.
I'm
I just
not-
need.
Yeah, so what I'm saying is I'm not reconsidering his ruling. I'm saying that right now, the law of the case is that he has decided that your jury demand was not timely filed. I'm not changing his ruling about that, but that is a ruling that if you don't agree with, you have a right to appeal to the Court of Appeals. Just like when we're finished today and I make a ruling, if either side does not like that ruling, either side has a right to go to the Court of Appeals. Does that make sense?
Yes, ma'am.
Okay, all right. Go ahead.
I would just like to, I have to mention that because it's relevant to the case. You don't need to overrule, but I do need to tell the story as this is being recorded.
Okay,
So
go ahead.
I feel like it's, okay, I just need 2 minutes uninterrupted.
Well, I
As a
can't
pro
promise
se?
that, but I will let you go. First.
Aaron
Go ahead.
cannot furnish, the plaintiff cannot furnish a notice of that set trial. They didn't notify
I'm
me.
sorry, I didn't hear you.
Yes,
The plaintiff cannot. Hold
the
on.
counter
Hold on.
plaintiff.
Stop. Let me tell you what I heard so you'll know where to start. Here's the last thing I heard was the plaintiff cannot provide a notice.
The
I didn't hear
plaintiff
you.
did not provide and still cannot furnish a notice of that trial date on January 18th, 2024. They never notified me. Now,
Okay.
let me tell you why they never notified me. On January 5th, I went to jail. On January 3rd, I had sent over evidence in this case to build my case. 2-3 days later, they processed a warrant, intercepted an ongoing case as I was trying to prove it, and just literally took me to jail. I'm working like $160,000 job if she wants to talk about character. I get off on a Friday, and then boom, Saturday, Sunday, Monday, I get out. As soon as I get out, Aaron had 0 documents inputted into the system for any discovery of anything. I get out Monday night, it's like 11 or 12 o'clock in the morning, she starts sending me documents. The next thing is like, there's a trial set, and here you go. There was never any notice at all. I get out January 9th, and they have court set January 18th. Now, January 11th, I had already set my, demand for jury. I had did it through the e-file system because they switched it from pro se, and I could just file email, and then they switched it. So I get out of jail, go in January 5th, and get out January 11th. Prior to January 11th, they never had any trial date in there. There was never any information, never any notice or anything. So I get out immediately, notice motion of continuance. I get out immediately, jury trial. I get out, and I had already had that jury trial on file as far as emailing it. So that's literally the reason why we motioned to recuse Judge Todd Wong, because I had stuff on file and they were just ignoring it. They're bypassing it. I literally have Aaron on the record, and I have the email right here of her saying that the respondent email that I've been sending documents to filed in East, or she never seen it. Before they even set that January 18th trial, I had called Marilyn, her representative in her office, to let them know, hey, there is a demand on file. And then even prior to that,
Your Honor,
I'm not done.
Hang on, Mr. Boy. Mr. Way, I tried to give you some leeway here, but I think I need to get you to focus on the facts that relate to the claims in the case that I am going to decide. I'm not going to decide this issue about the jury trial. That's not going to be.
So we can just appeal that then, right?
That's what I was trying to say
Yeah, all right,
earlier.
forget about it. I'll just appeal it because you guys aren't hearing what I'm saying. I just wanted this to be recorded on file.
It's not that
I just wanted to be recorded on file when they, sorry.
It's not that I'm not interested in what you have to say and the position you're taking. I am interested, but I am not going to overrule Judge Wong's decision. He's made it, it's done. And if you are not satisfied with that decision, your appeal to the Third Court of Appeals is the place in which you would deal with that issue.
Oh, yeah. All right, we'll just do it there.
So my point for today is just to focus on the issues that are before the court today, which are essentially a brand new trial on the eviction with the claims that the plaintiff has brought for non-payment of rent, as well as attorney's fees and other costs, right? That's all I'm here on with regard to the plaintiff's claims. Then your claims, the ones that I have jurisdiction over, which we'll sort out in a minute once I hear some evidence, right? And that's why I'm saying that at this point, we're just in the evidence phase. This is where I get facts, not argument, not legal discussion, just facts. What happened? Who did what? Who paid what? Who said what? Like, who did something? Those are the facts that I'm listening for, so that then, after I hear your closing arguments where you will apply fact to law, then I will make a decision, right? So give me the facts. What happened? Why shouldn't you be evicted? What did you pay? What didn't you pay? When did you pay it? That sort of thing. Make sense?
Okay, so I shouldn't be evicted because you don't want me to re-narrate this information, but the reason is the original petition. Past that, it's the next thing I just showed you, the document where I didn't need to pay anything to update until we get to trial here. Now they reset the trial, and to be honest with you, the way that you guys reset the trial, I'm not with it. And let me elaborate on that. One,
No. The trial was set. The trial was noticed. The trial was assigned to me. We're in the trial.
It's irrelevant. It's irrelevant. I hear you.
No, it's not. It's not that it's irrelevant. It's that it's not appropriate for now. That is something that you can complain about if you want to on appeal, but not for today. That's all I'm saying.
Well, no, I hear you. I hear you. All I'm using
I'm not saying it's not relevant. I'm saying
Yeah,
it's
I
not
hear you.
appropriate because it's beyond the scope of what we're doing today.
I
That's
hear
all I'm
you.
saying.
All
Okay.
I'm saying is, you guys, and I'm looking up the thing from Angela. It's literally a hearing, quote unquote, document. I could share my screen. She told me it's a hearing. So what I'm trying to get at by referencing the demand trial is that this is inappropriate right now. To have a trial when I'm not prepared for it because I've had so many documents, and this is why he's being recused right now. I know it's irrelevant, but I need to mention it since we're on air and we're going in. This is not an appropriate trial because it was designed to be from a jury. Is what I'm saying.
I understand that. I understand
past
that.
that-
We're not going to deal with that today because that is the subject of something you're going to do on appeal. So for one more time, I'm going to ask you, please, to stick to just what is relevant for purposes of our time together today, and that is the eviction issues. Did you pay rent? Did you not pay rent? And so forth. Now, in service of that, let me ask another clarifying question.
And there was a motion to transfer too. Sorry.
When you paid or filed, I should say, when you filed the affidavit indicating that you did not have the money to pay the appeal bond or the surety bond, did you understand that document to mean that you did not have to pay your rent also?
Ma'am, can I share my screen?
Yeah, you certainly can. But first answer my question. Did
am I
you
supposed to-
understand that document to mean that you did not have to pay your rent?
Which document?
Let me start over my question. Listen to my question. When you filed the affidavit that indicated that you could not afford to pay the appeal bond or the surety bond, when you signed that document and filed it, did you also think that document meant you did not have to file or pay your rent? Is that what you thought? That's my
not
question.
what I thought. That's not what I
Okay.
thought. The document said that I did not need to. It's not to Estancia Villas until the case is processed. It's either to the JP court or it's either to the civil court.
I don't
It
think you
is-
understand my question. Let me try again. And maybe you did understand it and maybe I got my answer, but let me clarify. I just want to clarify. When you filed the affidavit indicating that you could not afford to pay the appeal bond or the surety bond, when you filed that document, were you under the impression that that document relieved you of your obligation to pay your rent?
No.
Okay. All right. That's my question. You've answered it. Let's move on. Next part of your testimony related to the facts of the case, not the jury trial demand and all that. I just want to know about the facts of the eviction case. You may
Ma'am.
proceed with your testimony.
Am I on screen share right now?
Yes.
Okay. So stop screen share. Let's go to this. What does it say right here?
What I see on the screen is some email.
From Angela?
It related to a hearing confirmation. Yes. But again, Mr. Way, that has to do with the procedural issues related to your request for hearing or trial or juries and so forth, which is not what I'm entertaining today. That is going
hear
to
you,
be,
but look
if you
below
want to talk about it, the subject of your appeal, should you decide to appeal once the decision has been made, not the subject of what we're doing today. And so I'm going to rule that that's not relevant. We're proceeding and we're in the middle of the trial. So I want to know
Ma'am,
about the
can I
facts of
read-
the case. I want to know about the facts of the case. I want to know about your time at Estancia, your rent, your claims against the plaintiff. Tell me about those facts, not about setting matters for a hearing. Okay?
No. Listen, ma'am, look, it literally, can I read this out loud to you, please?
No, you don't need to read it to me because I can read and I'm looking at the document and I've
It
seen
says
it.
as
I
well
understood
as the plaintiff notice of rent default for motion to transfer. There's a motion to transfer the case. Please
I
stop acting
understand that. I understand
It
that.
literally says it right there. It's not just the merits. There's so much.
Mr. Way,
Okay,
Mr. Way.
Look, there's another one. There's another one. Here, check this out.
Hold on. Are you telling me that you want me to entertain a motion to transfer today? You have yet to say that, but if I'm
Ma'am,
now understanding you
You
to
tried
say
to
that,
shut me
then
down
stop.
consecutively and consecutively and consecutively.
Stop. I will add to our agenda a motion to transfer. Now, let me point out that when I was setting out the agenda earlier this morning, and I said there are the four things we're going to talk about today. You did not mention there was also this motion to transfer. Had you done so, I would have been happy to add it to our agenda. I will add it now. So I'm going to add number 5 to our list of things to do today is your motion to transfer.
Your Honor.
Hold on. It's a little late in the game for us to do it, but we will come back to that in a minute. Right now, we are in the middle of your direct examination. Ms. Du Bois is entitled to a cross-examination. I need you to finish her direct examination so we can get to her cross-examination and to any other evidence you have to submit so that we can complete the evidence phase of our trial. So I will add motion to transfer to the document, which, as you point out, includes in the notice the merits of the trial to be discussed today, which is what we're doing, along with all those other things that we've added to our agenda. Now, move on, if you would please, to the next fact to tell me about your case.
I would like to be 100% respectful with you guys, but I think you're overlooking a lot of these facts. The first thing I want to mention, if I can just get 1 minute to go off, the first thing I want to mention is that you guys were already aware that there was a motion to transfer. Why was that not on the case? I'm not even done with that. All of my documents have been on file. Nobody looked at any of my documents prior to this. I'm trying to tell you about the demand for the jury.
First of all, that is not a correct statement because I did look at your documents before the trial. So I would appreciate you not assuming things about me. I'm not assuming anything about you, and I don't want you to assume anything about me. I appreciate that you have your opinion about these things. I respect that, but I need you to respect my ruling. Here is my ruling. We are in the middle of a trial on the merits. We are hearing at the moment your direct testimony, which is about the facts that relate to what happened in the case. So I need you to focus your attention and your testimony on what happened. Who did what? What did you pay? What didn't you pay? What did they do? What didn't they do?
I hear you.
And when you're done with your testimony, then I'm going to hear argument, at which point you can tell me these other things that aren't testimony. But in the middle of your examination, I just need to hear the facts.
I have these documents to protect me as far as those go. Everything else, I guess I can't talk about until you're ready for me to talk about.
I want you to talk about anything else related to payment of rent.
Yeah.
Like if you made a payment, I want to know about it. If you didn't make a payment, I want to know about that. I want to know about anything related to the eviction case before we move to the next thing.
Yeah, that's it. I have my documents on file.
All right. Apply those facts to any legal arguments, right? Like state the statutes that might apply, or legal theories or cases that relate to the argument
As to my client's entitlement to $2,600 in attorney's fees. Your Honor, my clients testified that Mr. Way has failed to pay rent. Mr. Way is the person responsible for rent under the lease contract. There's evidence presented to the court, that testimonial evidence that he failed to pay rent, any rent, except for $720 at the beginning of his tenancy. And this is also proven by Plaintiff's Exhibit 5, which was the ledger showing that Mr. Way only paid $720 when he moved in. No other entity has paid, no other payments have been applied to Mr. Way's account with my client. And so, Your Honor, this is a simple non-payment of rent case. There's additional reasons for which Mr. Way has defaulted under his lease that my client has provided as well, which is the conduct-based violations that was pled. There's evidence on file to show that Mr. Way was arrested for a criminal harassment charge that is a breach of the contract and therefore a default under paragraph 23.1B. And so again,
let me ask you about that. Hold on, let me ask you about that. Does your lease agreement indicate that anybody that is even arrested, even if they've not been convicted of something, is a violation?
That's correct, Your Honor. Criminal conduct under paragraph 11.1A.
Well, it's not criminal unless you've been convicted of it, right?
Your Honor, he has been charged with a criminal offense of harassment.
But that doesn't mean he's guilty of it, right? I mean, people get arrested all the time and then they go to trial and they're acquitted. That doesn't mean that they've, in fact, that means the opposite of
Your Honor,
criminal activity. It means they've been acquitted of what they were accused of. So I'm just trying to understand if your contract with Mr. Way says that he has to have actually committed criminal conduct or simply that he's been accused of it.
Your Honor, the lease contracts prohibits a tenant from engaging in criminal conduct. And then under the default of lease provision, it provides that it is a default of the lease for you or any guests or occupants to violate the lease criminal or other laws, regardless of whether or where arrest or conviction occurs. In addition, Your Honor, 11.1B prohibits engaging in disruptive, harmful, loud or obnoxious behavior. My client testified concerning that conduct, as well as threatening conduct against others, including staff. That was 11.1C. My client testified concerning
Objection.
threatening
Hearsay.
conduct.
Objection. Hearsay. Where's your evidence? Where's your evidence of it?
Mr. Way, hang on. I'll overrule your objection because we're not in the evidence phase. She's not offering evidence at this time. She's just summarizing what she believes the evidence has shown, not giving evidence. So that's the difference. Go ahead.
Ms. Cantu also testified about Mr. Way's conduct at the property, prohibiting or affecting their business operations, which is a violation of 11.1D. And so for these reasons, these violations of the lease are a default under paragraph 23.1B and is another basis for my client to seek possession and terminate Mr. Way's right of occupancy of the premises. So at this time, Your Honor, my client has the superior right to possession based on the contract, and they are seeking the amount of back due rent and attorney's fees, and we'd ask that the court enter the judgment that we have proposed.
All right. Thank you. Let me ask another point of clarification. You've indicated the back due amount that you seek, which, if I understood your calculations correctly, were calculated by multiplying 1356, which is the amount of the monthly rent, times 6 months. Was that correct?
Correct, Your
Honor. But I didn't understand, and if I understood your calculation earlier, you calculate that number to be $8,136, correct? I didn't check your math. I'm asking about that now. And just so you can know where I'm headed with this, if that's the calculation, I don't see where you have given Mr. Way credit for the $720 you all admit he paid. And so would it not be?
Your Honor, this is just for the non-payment of rent. In eviction cases, we can only seek a judgment on the non-payment of rent. And so the $720 that he paid at the beginning of his tenancy would have been for prorated rent for the month of August.
Objection.
I see. So you're not
Objection.
asking for. Hang on, Mr. Way. I promise you're going to get your turn. I'm just asking her to clarify what she's asking me to do, and I'm trying to check her math. So let me get clear with her about what she's asking for, and then you can give me your closing argument. So that I'm clear, the $720 that he paid, that you all admit that he paid, was not applied to September, October, November, December, January, or February, because it was not due for those months. It was due and paid prior to September of 2023. That's the position you're taking?
Yes, Your Honor, and that is evidenced by Plaintiff's Exhibit 5.
Way, it is now your opportunity to give me your closing arguments, and you may begin your closing argument at this time.
Yeah, so I moved into Estancia Villas August 21st, and I had paid the $720, fell on some hard times, and there was a delay in payment on my behalf. UDR, a $15 billion corporation, proceeded to collect the asset of Estancia Villas or Steadfast Management. They changed everything up. So September 15th, I couldn't even pay rent. Nobody in the 341 buildings here could pay rent until around September 15th. On the 25th of September, Jennifer Mercado showed up and gave me a notice to vacate. Keep in mind that I had moved in with rent paid, $720 advance deposit and everything for September, for the 1st of September. So between the 1st of September and the 15th, I wasn't even allowed to pay. And then 7 days, or not even 7 days, 10 days after that, she shows up with a notice to vacate. I didn't even get 1 month to do anything. It was just a notice to vacate. In addition to that, I made multiple attempts that I do have on record and on file to pay a portion, even being 80%
Your Honor,
of the
I'm
rent.
going to object just because there's no facts into evidence or testimony in
It doesn't matter.
ways.
I'm going to overrule the objection.
Yeah, I'm just telling the story. I'm summarizing.
Yeah, but Mr. Way, let me just point out, technically she is correct in that your argument must relate only to those things that were produced in evidence already. And what she's arguing is this is new information. I'm just going to ask you to tell your story based on what we've already discussed. I don't want you to.
Okay, I hear you. Well,
all right, go ahead.
Yeah, for sure. I got you. There's a book on file as far as the e-files go and all of my motions and documents. Everyone's been overlooking. This has been going on since December. This is the whole reason why everything's becoming complicated now. There was just literally an eviction appeal. It went to another plaintiff petition for JP courts, and now there's like 10 involved. You have been assigned to be the judge on all cases in the with respect to Travis County at law. So essentially, it's like a cluster. I don't want to use the word here, but basically what I'm trying to get at is that all of my documents, including what I just mentioned, was on file. The judge could have seen it, Aaron could have seen it. And when I say that, I have literally written a book on this, what my experience has been. And it includes me showing up on August 21st and then not having the ability to pay rent until the 15th, and then getting a notice to vacate on the 25th. And then after that, having a month before trial, and then it being paid on my behalf because they've been monitoring me inside here this whole time. And then boom, the original petition in conjunction with my appeal. And that's why we're here right now. And just to further reiterate, there's a demand for a jury trial on here. I know that now is the appropriate time to talk about it. So as pro se, I was able to file that electronically through email. That should suffice as far as me requesting, because I had 4 subpoenas literally delivered by the constable through the same channel. So it doesn't make any sense for my demand to not be on there. In addition to that, when I came out of jail, this is the main thing right here. Judges, I know you can't overrule it, but I'm mentioning it because it's a fact. Like the trial that's being handled right now, it's inappropriate. For one, Angela told us that this is going to be a hearing. So I'm not prepared because I was under the impression.
But hang on that point, if you look carefully at what you received from Ms. Burks, which you shared with us on your screen, there's
another one prior to that. I hear you. Notice to me, the defendant, that there was a trial in state and I had just gotten out of jail. There was no fair warning or anything like that. They're just like, hey, there was an act of God. Literally, the trial is reset. Now they're already aware of my demand for the trial and they just reset it. Here we are. They reset, they had the opportunity. And I've told everyone, not just you, Aaron, Colton, everybody, there's a roster of people that have been stressing out, sending emails, linking emails, e-filing for this demand trial. On the 18th, not only did they not provide anything prior to that, as far as setting that trial, but then they also, in conjunction, the same violation that I went to jail for, Aaron and all of the representatives here decided to imitate and mimic that with Travis County Sheriff's Office, and then literally got declined. So I went to jail for harassment, trying to plead my case. I get out, they file another harassment charge on me and then get declined on it, and then literally try to spin the argument, and then without any notice, try to set trial. Then they reset trial, and then they say hearing, and I have a demand trial since the 11th. And not only did I file this thing on the 11th, but Travis County's website says within 48 hours, they're going to process. So they actually accepted it on the 16th of January, 2024. They let 3 days extra elapse. What I'm saying is I've been on top of it as far as submitting my documents in the proper way. And basically, they've just been overlooking it and trying to do other tactics in conjunction with different departments to minimize me and prevent me from speaking. There's a lot going on here. Now, in regards to the other, if I can share my screen with you again.
To me, that there may be some confusion about what your client requested in justice court versus what you've requested in the trial de novo. And so I just wanted to be clear so that I'm clear, because it's my understanding that when you get to the county court and you file pleadings on file in this trial de novo, this new trial in the county court at law, at that point, your pleadings can ask for any number of things that may or may not have been part of the prior proceeding in justice court. And so I think there may be some confusion about that. And I thought it might be helpful if we just kind of scroll through that petition. And so if you'll just slowly scroll down to the requested relief and the allegations regarding unpaid, depending on the nature of the motion and what you're seeking, is something that might have been dealt with prior or should have been dealt with before today. I don't know. Tell me what it is you're requesting in your motion to transfer.
Yeah, the motion to transfer is strictly based on biased decisions made by Travis County at Law 1. That's what I need to get out of Travis County at Law 1, because you guys have been taking advantage of me seriously. For one, wait, hold on. I just want to know the nature of the motion, not
all the details why you think that motion should be granted. I'm not asking that question at the moment. First, I'm just asking, what is it that you want in your motion to transfer?
First of all, I wanted this to be a actual hearing, actual trial, not a hearing. And I wouldn't have done it online because I wanted to do it in person. So the reason to transfer the case was because they put an order of constraint that was vague, that
You want to transfer what to what is my question. What do you want to transfer?
I want to transfer this case to another county. And I also there's another motion to escalate higher. So there's a motion to escalate higher, and there's also a motion to transfer out of Travis County because they've been biased. And I've also reported that judge to the State Commission on Judicial Conduct. I've reported him already.
Okay, so that's
attach affidavits to that, and he failed to do so.
all right. That motion is denied. So I can't deal with that. Now, there are another matter related to some other cases that you have pending in Travis County. Is that right, Mr. Way? Okay.
Yes, ma'am.
So let me here's what I want to say about that. I am aware only of this cause number related to the eviction with Estancia today. What I would ask you to do is first confer with whoever is on the other side of that case, whoever's representing who you're suing, or if they're representing themselves, email or call or coordinate with those folks and with Angela Burks to clarify two things. One, what's the cause number? Or a couple of things. One is, what's the cause number? Two, when are you all ready for a hearing or a trial or whatever proceeding you need me to preside over? When are you going to be ready to do that? And then send in to Ms. Burks, Angela Burks, whatever matters you need me to hear. So if it's a trial on the merits, fine. If it's a trial, then I can have access to the pleadings and so forth. If it's a hearing on a preliminary motion, for example, fine. Just let me know. She will let me know, but I need you to confer with whoever's on the other side of that case so that it's clear what other pieces of litigation are pending that you need me to hear. And then I will clarify my assignment with the regional presiding judge about whether or not I'm needed and assigned to those other cases. But the first step is for you to communicate with whoever's on the other side of those cases to figure out, are we ready? What are we going to hear? What do we need the judge to do? And when can we be ready for those things to be heard so that a hearing or a trial or whatever can be scheduled on those matters at a time that's convenient to my schedule and to your schedule and to the opposing counsel's schedule. So that's the first thing that you can do. And when you've communicated that to Ms. Burks, she'll let me know that so that I can then work with her on a scheduling issue so that we can all be here and available on the same time. And we can do that either in person or on a remote hearing. Either one is fine with me, as long as it's a convenient date and time for everyone that's involved. So that's what I wanted to say about those other matters that are pending. The final thing I want to say about these sort of other matters is Mr. Way mentioned that he wanted to have something happen in person. I just want to point out that I was told that a remote hearing was requested. I don't know if that's accurate.
Not the trial.
We use the terms trial and hearing interchangeably, particularly when we say on the merits. That means the whole shebang to us. So I appreciate that that might not be precise and that might be confusing. I get that. But when you are told in a note or a notice that the merits are going to be decided, that is a final matter, right?
Okay, then I had objected to that.
Call it a trial.
To the case.
I'm not arguing about it. I'm just telling you what I was told. That's all. My point here is in offering clarification and explanation for what I'm doing and why I'm doing it, because that is the information I was provided. I'm not saying it was accurate, not saying it was correct. I'm just simply telling you that's what I was told. So I was told we were doing a hearing on the merits. I was also told that the parties agreed to a remote proceeding. And that's why we conducted it remotely. I was perfectly happy to show up in person, but I was told that the request for a remote hearing. And so that's why we're having this hearing in a remote venue. All right. So that's the information I have regarding all of the other matters. I don't believe there are any other sort of other matters other than the merits of the case. And if there are, what's that?
It's that considering the original petition, there should have never been an eviction to begin with. We shouldn't have even been here. So anything after that point, now you're asking for all types of stuff, is nonsense, because there was zero cause in the first place. You can't even be here, is what I'm saying.
I understand that that's the position that you take, and that's one of the reasons why I wanted Ms. Du Bois to show us her petition so that you could be clear and we could all be clear that when you get to a trial de novo in the county court, which is where you are now in the county court at law, you get a trial de novo, meaning a brand new trial with brand new pleadings, a brand new request, and brand new allegations, even perhaps.
Well, having said that, they didn't subtract it.
Stop. Let me finish, please. So that's one of the reasons why I wanted to go through that process of going through the pleadings, because everything in that pleading is before the court. I understand the position that you're taking about feeling like you hadn't done anything wrong, feeling that, you know, people had it in for you. I understand all that you've testified about that, and I'm taking that into consideration. I'm simply pointing out that all of the issues are before me at the moment, and I'm going to make a decision about that. And I want to just clarify, there's nothing else other than the merits of the eviction case now that has to be decided. Is that right?
Your Honor, except for our motion under 510.9C.
Well, that includes one of the requests you're already asking for, which is immediate possession. That's redundant to what you're already asking for in the case. So I think we'll get that.
Okay.
It'll be subsumed.
Well, you guys are surely getting appealed.
Just
Just know that.
So stop, Mr. Way. Hang on. She's trying to clarify something. Excuse me. She's trying to clarify something. I just want to be clear about what she's asking me for. I appreciate that there are different avenues to the same location, but I'm going to deal with all that you've asked for and cover all the requests as it relates to the substance of the eviction. Is there anything other than immediate possession, rent, attorney's fees, and the criminal conduct?
Demand.
Is there anything else? Excuse me. Is there? Oh, please, you both have to wait until I'm finished, because A, it's just rude, and two, Miss Duet can't take it down when we're all talking at the same time. Let me finish, please. I'm simply asking if there's anything else other than related to possession and rent and so forth and all that. Is there anything else that we've not dealt with that is supported by a pleading on file in this case? Yes or no?
Your Honor, I just simply want to clarify that plaintiff is requesting the judgment be signed as well as the order for immediate possession. That is all.
I understand that. I think that relates to the substance of the eviction. That's going to get dealt with. Is there anything else?
Appealed, for sure.
Is there anything else, Mr. Boyd?
No, Your Honor.
Is there anything else, Mr. Way?
Let me ponder for a second.
Okay.
To the merits of the eviction, without anything else? Yeah, without anything else, nah.
Okay. All right. Then
Just the original petition.
Sorry?
Just the original petition and where we are now with respect to where we are now.
You've made that argument. I understand that.
They need to dismiss the case, to be honest, and restart and sue me for rent is what needs to happen.
I understand your position about that. I get that. I understand. You've made that real clear. I understand that. I think Ms. Du Bois has made her client's position very clear. I get that.
Mm-hmm.
I am now going to rule on that because I think we have dealt with everything else.
Mm-hmm.
Make sense? Okay. All right. Here we go. First, the plaintiff's request is granted in part and denied in part. The part of the plaintiff's request that is denied is a judgment and eviction based on this allegation of criminal conduct. I simply think there is insufficient evidence. Mr. Way, I need you to mute your microphone because you're editorializing and I can't have that interruption, please. Just mute your microphone if you would until it's your turn. Okay. So the part of the request by the plaintiff based on criminal conduct is, I believe, insufficient evidence to prove that. And so that request is denied. The part of the plaintiff's request that is granted is in all other respects. I do not find credible evidence that rent was paid when it was due. There is ample evidence that Mr. Way paid only $720 in the month of August of 2023, and that he has not paid a penny since then, even though the lease agreement requires that he pay $1,356 per month. Those payments were due on the first of the months of September, October, November, and December 2023, and January and February 1, respectively, 2024, and there is no evidence whatsoever that he paid any of those sums. I believe that Mr. Way thought that he was not required to do so. I don't believe that he is correct about that, and so I do find that he owes the sum of $8,136 for 6 months of rent at $1,356 per month for a total of $8,136. He's not paid that sum. He owes that sum. And so until judgment in favor of the plaintiff is granted in that amount. There is some testimony by Mr. Way that some roughly $4,000 or so, $4,068 was paid on his behalf by the representatives of this big corporation that owns the apartment complex. I do not find that evidence to be credible. And so I don't think that the managers who are employed there seems unlikely to me that they would be paying rent on a tenant's behalf to the tune of $4,000. I simply just don't find that credible. And so I'm not going to give that any weight. Mr. Way moved in. He hasn't paid the rent from September to now. He owes it. Judgment is granted for the plaintiff in that amount. There was a request for court cost. I'm going to deny the plaintiff's request that Mr. Way pay those. I'll order that each party pay their own court cost, if any. And so if you have court costs, you pay your own court costs. There was also a request for interest sort of in general on the sum that I've now ordered the judgment for in the $8,000 amount. I will not order any pre-judgment interest. I will order post-judgment interest until that sum is owed is paid in the amount of 6% per annum. There was a request for attorney's fees since the plaintiff has prevailed on their claims, at least prevailed in part on the request for the eviction to the tune or to the on the ultimate issue regarding the non-payment of rent. So I do find that $2,600 in attorney's fees for all that's been done throughout the case is a reasonable and necessary fee, and will order attorney's fees. Those attorney's fees will be due and payable on or before April 1, 2024. That way I'll give Mr. Way some opportunity to pay that. He's indicated that he has a sufficient income. He indicated his income was in the $160,000 range. And so despite the affidavit of inability to pay the appeal bond, he's testified today that he has income sufficient to pay the attorney's fees. And so that sum will be due on or before April 1, 2020.
I object.
That's okay. You can object, but right now you got to pause your thoughts.
Sorry. I never said that. I just want to clarify. Gotcha.
Well, I'm sorry. That's what I heard. If I misheard you say that, or maybe
Can I correct you?
Sure.
So the interception from Travis County Sheriff's Office prohibited me from maintaining my job.
You can correct
So I don't
me
have a job,
about what
is what
you
I'm trying to
said
say.
about the $160,000.
I was making $160,000. I had gotten the job as a high-end job. Travis County Sheriff's Office arrested me, which prohibited. I got out of jail and lost a $160,000 job.
You lost that job. Okay.
Yes,
All right.
ma'am.
Well, that's great. Well, I tell you what, then, based on that information, I will amend my order, and I will give you until May 31 to pay the attorney's fees. I'll give you a little more time to get that paid. So I'll change that based on that information. And thank you for clarifying that. I will order the payment of the $2,600 on or before May 31, 2024. I do find that the plaintiff has a superior right of possession and will grant immediate possession to them because they are entitled to it. And I don't think there's I think the evidence is clear that you can't rent a place, not pay the rent, and then continue to live there. So I do believe that they're entitled to immediate possession. And I believe that the rent writ requested by the plaintiffs in that regard for immediate possession is both justified by the evidence and appropriate under our law. Let me just check and see if there's anything else. I think that's everything that covers all of the requested relief. To the extent that Mr. Way has counterclaims on filed, they're all denied because they are either in excess of the court's jurisdiction regarding the 10 million or $200 million in damages that he's requested for what might be considered tort claims. And then with regard to the criminal claims he seeks, obviously I do not have the jurisdiction to deal with those matters, but I think he understands that if he wishes to pursue those, he has other avenues, both in the federal courts or in the prosecutor's office or the police with regard to other matters. And I think he understands that. We've explained pretty thoroughly the right of appeal that each party has if they don't appreciate this proceeding and the rulings that I have made today. So here are the next.
How long do I have to appeal?
I can't give you, that's technically legal advice, which I'm
5
not
days?
allowed to do.
Thank you.
I said I am not allowed to give you legal advice, and so I can't answer that question.
No worries. As soon as this is done,
That,
as soon as it's done.
up to you. I would say sooner the better, but I'm not allowed to give you advice about your deadlines because that's in the nature of advice which judges are prohibited from giving. So I can't tell you the answer to that, but I can generally say that the more quickly people do things, the better.
Gotcha.
So
We're going higher for sure. Thank you.
okay, so here's the next step then that what will happen. Ms. Du Bois is going to be directed by the court to prepare the documents because she represents the plaintiff and the plaintiff is the prevailing party. Typically, we would ask the prevailing party to draft the documents. She will do that. She will send them to you, Mr. Way. She's going to send them to you by email. Ms. Du Bois, in your email, please indicate that you need them back by within 5 days. So, Mr. Way, I'm going to give you 5 days to review the documents that she has sent to you. That should be enough time. You probably could do it sooner than that. I don't know what you may want to talk to somebody about it. I just want to make sure you have enough time to think about it, review it, make changes or whatever. If you have changes to the document because you believe they are inaccurate, then redline the copies that she sends back to you and tell her, you don't want it to say this, you want it to say that, or whatever. So send her what you think that document should say if you disagree with what she puts in there, okay? Once you hear back from him, Ms. Du Bois, then send those documents into Ms. Burks, and then she will send them to me. I will review them, and I will sign the document that I think accurately reflects my ruling today, okay? And it should be a complete and final order, and be sure you include that language in it so that it's final and appealable and can go up to the next level. So, Mr. Way, she's only going to wait those 5 days. If she hasn't heard from you, then she's going to send that draft over to Ms. Burks, who will then send it to me.
I have not been able to communicate with Aaron not one time since the trial. Or
it's just by email. It's just by email. You don't have to have
I have not been able to communicate with her.
Yeah, she is being directed to draft the document. You are being directed to send her your changes if you have any. You may not have any, because she may get it right and correctly reflect it. Now, let me say two things about that. One, if she doesn't hear from you within those 5 days, she's going to send it on. If she does hear from you within those 5 days, she's going to either make the changes you've requested because she's agreeing to them, or she's going to then send to Ms. Burks her draft and your draft. You are also welcome to send her draft and your draft directly to Ms. Burks. You can do that too, as long as you do it within those 5 days. So everybody can send whatever they want to Ms. Burks, who will then send it to me within that 5-day period after Ms. Du Bois drafts them and sends them to you. I'm going to direct her to get that to you by Monday of next week, March 4th. Okay, so it shouldn't take her too long. She's required. Can you get it to him by Monday?
Turner, I can get him to him in the next 5 minutes.
There you go. So no later than Monday, Ms. Du Bois is going to get it to you, and no later.
You have 5 days, Aaron. Calm the hell down.
Excuse me. And then Mr. Way will have until Friday of next week to make his changes. Everybody by Friday of next week must send what they've received by then to Ms. Burks. Okay.
So then after that point, you're going to initiate your order, and that's going to come from you.
After that point, I'm going to review what you have both submitted to each other. You're either going to submit an order that you both agree is correct, or you're going to say, I want this language, and the other one is going to say, no, I want that language. I am going to then review them both, and then I am going to sign the one that I think accurately reflects my ruling. And if you both get it wrong, I'll probably draft my own. But that seems unlikely.
I just want to clarify, the document coming from you, the judge, that's going to be the final document that I can appeal,
That's going to be the final order on the merits of the case that reflects what I've ruled today. That's correct.
Okay. And so when you initiate that.
Just to be clear, here are the deadlines. Ms. Du Bois has until Monday, close of business, to get the order to you. You will have until, I'm going to adjust that a little bit. I'm really going to give you 4 days because I want you to get it back to her by the end of Thursday of next week. So if you want to tell her you got changes to it, you have until the end of the day on Thursday to make those changes. I want by noon on Friday of next week for you all to send to Ms. Burks what you believe is a correct reflection of my ruling. Okay?
Okay.
I want that to Ms. Burks by noon so that she can then send it to me and I can look at it and get it back to you. I may or may not get it back to you that same day, depending on when I get it and what else I'm going on. You know, maybe a hearing that day. I don't know. But I want them to Ms. Burks by Friday of next week so that I can then review them and sign the one that I believe most accurately reflects my ruling. Now, Mr. Way, Ms. Du Bois, these orders, this order that we're talking about should include only those things that I'm ruling on and the request that I'm granting, the request that I'm denying, all that we've discussed today. Mr. Way, when you react to what she writes, that is not an opportunity to re-argue the things that we've talked about, right? It's just an opportunity to make sure that what she puts in that draft order accurately reflects what I've ruled, right? To the extent that you want me to reconsider the jury trial, I'm not doing that. That's order stands.
Yeah, we're going to escalate. Yeah.
That's fine. That's okay. I'm just saying that the purpose of this order is just to reflect what we're doing, not an opportunity to re-argue. You can re-argue that in another case, right? In another.
Gotcha.
This order just needs to say, here's what Livingston is ordering. And that way, when you go to the next level, that court can say, oh, here is what Livingston did. She got it right. She got it wrong. But here's what she did. And so this order needs to say what I did, not what you all think about what I did, right? Not whether you agree with it or disagree with it. Just is this what I actually ordered? And that's all that needs to be in that order, not your opinion about it. Just did I accurately say denied, granted, ordered, amount of money, amount of interest, attorney's fees, whatever, right? Speaking of attorney's fees, in addition to the $2,600 that's due on or before May 31, 2024, the appellate fees testified to in the event of appeal, those are granted as requested. And so that should be included in there as well. So again, we just need an order that says, okay, we had a hearing on February 29, 2024. Here is what Judge Livingston ordered. Yes, no, granted, denied, money, interest rate, so-and-so. That's what she did. And then I'm going to sign that. And then if anybody wants to appeal that, now the appellate court will know exactly what I did. And then they can decide. They can grade my paper, right, and decide whether I got it right or wrong, but at least they will know exactly what I ordered and what I did not order. Okay?
Your Honor.
In the meantime, I'm going to get 2 things because the writ of possession is going to issue immediately. You can send that over to Ms. Burks today. You don't have to wait for that for next week. You can send that today because your client is entitled to that today. Send that to Mr. Way and then send that to Ms. Burks today. Mr. Way, if you have objections to that.
I have objections to that.
No doubt about it. But send your objections to Ms. Burks as soon as you get that. And I will wait until later in the day to sign it, just to give you an opportunity to make whatever changes you think need to be made to it. But I will sign that one today.
As far as the eviction goes?
I will sign the order for immediate possession today because they're entitled to that. And then you have avenues that you can take related to what you want to do next about all that. But I want the order because they're entitled to it today. I want that one signed today. The other order can wait. Okay?
What about the property then?
You're asking me questions related to legal advice that I cannot give you. So I can't give you legal advice.
Okay, so I can appeal this, right?
Absolutely. Well, I believe that that's also a question about legal advice, but I think I've already said that my decisions are subject to being reviewed by a higher court. That court is called the Third Court of Appeals.
Okay.
Okay?
Let me get on
All
my appeal
right.
then.
All right. Take care, everybody. It's nice to meet you all. Mr. Wade, don't forget on those other cases, you need to visit with the opposing side for
I
that.
can't,
And then
Judge
schedule
Livingston,
that.
I've already
I can't
talked.
hear you.
Hello?
Okay, I can hear you now.
Okay, I was just telling Mr. Wade to be sure to deal with, talk to Ms. Burks on those other cases. And I believe that concludes our time today. Thank you. Good luck to all of you.
Your Honor,
And
may
thank
we-
you, Ms. Duet, for taking it down for us as the court reporter. Thanks to Mr. LaRue for handling the Zoom call for us. Appreciate your assistance as well. You all have a great day, and we are adjourned. You may be excused.
That's all, folks.